Hi, this is Jim Cunningham, and we're going to talk about living trusts. Are you worried about how much it all costs, right? Because if you don't know much about something or you're just starting, because this is really confusing stuff, one of the first things I ask is how much. If somebody says, "Hey, Jim, you really need the new 2024 whiz bang," I'm like, okay, well, how much is it and what does it do? Because that's a normal thing to ask. And money's money, and I get that as a lawyer. And certainly, if you're watching this and you're thinking about setting up a living trust, or revising your estate plan, revising your living trust centered estate plan, money, it does matter. And it's something you're going to want to know. So, why and how do living trusts and other essential estate planning steps to safeguard yourself and your loved ones? How do these work? Right. So, what's the why behind it and the how? And we're going to talk about that. And is it really worth the legal fees? Because this is something that people, when I talk to people, they say, gee, this, I mean, it doesn't happen that often where people go, gee, this seems like a lot of money. Actually, what people say is, wow, this is a lot of work. And I'm kind of surprised that it wasn't more money many times with our clients when they're done with the process. But when going through this, really, you got to ask yourself, is it worth not only the money, but the time and the effort and the headspace, although it's kind of minimal headspace, to get your affairs in order in a way where you avoid probate. So I was thinking, getting ready for this, we should probably have a mug that says probate stinks or some other kind of word. But because it really does stink, and we'll talk about how bad probate is very briefly, and give you some numbers on that. So if you're watching this on YouTube, please subscribe to our YouTube channel, and there's a little bell that you can be alerted when we drop our content, which is typically every Thursday at 6 p.m. Pacific time. So I'm Jim Cunningham. I'm a partner at Cunningham Legal. I have 30 years experience this year. We have offices throughout the state of California. I'm a certified specialist in estate planning, trust, and probate law, securities and insurance licensed, and a pilot. So I have a broad base of knowledge on all things estate planning and how these assets work in the living trust. We have a big group of attorneys here with us now. We are not a big firm. We are what is called a boutique firm. So we're a specialty firm. We essentially handle all things for high net worth individuals, high income individuals, dealing with trusts and trust administration and real estate and business entities. So typically centered around the mass affluent. I'm a lawyer. When I say you, there is no attorney-client relationship. This is not legal advice to you. This is very important to understand. Don't watch this. Go out and do a bunch of stuff just because you saw this on a video. Very, very important. You will want to consult with an attorney. And if you choose to use our firm, great. And if you already have an attorney, that's fine too. But please, this is for information only, maybe a little bit of entertainment, but definitely information. So is a living trust really worth the legal fees? That's a really good question because a lot of people are focused on probate. A lot of people are focused on avoiding probate. So when you have a living trust, you still have to do stuff, and that's called trust administration. It's a terrible word. All that means is all the stuff that people have to do after somebody stops being trustee. So if I set up a living trust and I become incapacitated, the trust administration process starts. So somebody else steps in my shoes and administers the trust typically for my benefit. And then certainly when I've passed away, they're administering the trust for the benefit of my loved ones, right? My children, my spouse, whoever it might be, my surviving spouse. But if you don't have a living trust, there is a process that happens at incapacity or death. And it's very important to understand incapacity. It is the probate court in California, and it is the probate court in the vast majority of states throughout the United States. It is a court proceeding that you have to go through if you don't have a plan in place or the plan somehow is defective or out of date. So normal probates are a hassle and very expensive. If you have a will, that is a ticket to probate court, okay? If you have a will, you're not avoiding probate court. I would say typically, if you have assets currently, as we are doing this webinar in 2024, if your assets are under $185,000 or $184,500, don't know why they didn't round up. If they're under that amount, then it's a different process. It might be a single court hearing. There might be no court hearing. It might be an affidavit procedure, depending on the nature of the assets. And we do cover that in other webinars. There is a bill, AB 2016, that is in the California legislature. It's been sent to the Senate Finance Committee, and it is seeks to raise that limit to $750,000. So that creates a whole other host of issues that I won't get into. If you inherit a condo, you and your jerk brother and your jerk sister, the three of you, and you inherit mom's $600,000 condo, guess what? You still have to sell it. You still have to administer that estate. Now, you may not be in probate, but you're going to have to get along with your two jerk siblings. So probate in California, their lawyers talk about a formal probate. This is not where you put on a tuxedo and tails and spats and a cane and a little top hat. A formal court probate is a very long procedure, and it takes typically 16 to 24 months. The absolute earliest a probate can end is about 9 months. But again, everything, all the stars have to be aligned. The judge has to show up. All the people have to do their job. Everything has to happen on time. And guess what? That doesn't happen, right? Not in the real world. So what we're seeing in the real world is 16 to 24 months. Probate fees are 4 to 8% of the gross value of the estate. So if an estate has no debt, it's going to be 4 to 8% of the assets. But in our example here, Wanda, her probate estate's $1 million, meaning she dies and she owns a house worth $1 million, but there's a $950,000 mortgage. The probate fees are still $50,000. Now that's $25,000 to the lawyer, $25,000 to the executor. So the executor fees are in there. These are not all going to the lawyer. Really, it's slightly less than $25,000, but there's some costs in there, filing fees and appraisals and things like that are court mandated. And, so if people inherit Wanda's assets and it's $1 million estate with a $950,000 mortgage, it's basically 100% probate fee. So you can kind of think of it as a bit of a tax. So, and we have a probate fee calculator on our website. I'd encourage you to check that out. There'll be a link in the notes. And you can put in, if you put in your assets, it'll calculate what the probate fees are in your estate. So the gross value of all your real estate, gross value of your bank accounts. There's some things that aren't included, which we'll cover a little bit later. So, probate, again, it depends on the value of an estate. And these are some snippets from our probate calculator from our website. $1 million estate pays $46,000 in attorney's fees and executor fees. Now, this is excluding costs. So that $50,000 figure I gave includes those costs. Our probate calculator is only calculating the executor and attorney fees. They're not calculating the costs that go with that. A $3 million estate is $86,000, and a $10 million estate is $226,000. I will tell you that when you compare that to the estate planning fees, they're orders of magnitude smaller. It is pennies on the dollar. And you'll see, certainly if you have a larger estate, you absolutely want to stay out of probate court. Another thing, a bad thing about probate is it's all public. So the minute your loved ones inherit from you, that is public knowledge. The amount of their inheritance is public knowledge. So a lot of people don't like that idea. It's a fact, and there's really not a whole lot you can do about it. So how do you avoid probate? So we avoid probate with a living trust. So probate's expensive. It's a hassle. It's public. Living trusts are private. They are, generally speaking, more economical than a probate proceeding. And they certainly can be wound up in sooner than 16 to 24 months. So there still is a baked in time period there. But I would say the minimum is about 6 months. There's a 4-month waiting period in there. And we cover that in other webinars. So what is a living trust? What's a living trust centered estate plan? Well, a living trust centered estate plan. So a living trust is like part of the meal. It's like the pork chop on the plate, and you got vegetables and you got maybe mashed potatoes or something. That's dinner. So what we're talking about is a living trust is part of the estate. Okay, so it's part of the estate plan. There are other documents that go with it, but it's a set of documents, including a living trust, that work together, right, to provide a structure, to provide the legal authority for somebody to act on your behalf and not have to go to probate court. All right. So this is in the event of incapacity or death. So if I have a stroke and I have a bank account with just my name on it, I can't sign a check. I mean, maybe I'm unconscious, right? And I'm in a coma. I can't sign that check. Someone else is going to have to sign for me unless I have a plan in place. That person, my loved ones, are going to have to go to the probate court to get authority for someone else to sign my name. The same thing if I'm dead. If I'm dead, I'm not there to sign a check. I'm not there to sign a deed. So that's why people go to court and they get that authority to act on my estate's behalf, because there's no one living, there's no human with a heartbeat that has signature authority for the deed or the bank account. So pretty kind of Captain Obvious basic stuff. So what does all this cost in 2024? So I'm doing this in June of 2024. And I will tell you, since we came out of the COVID pandemic, things are different, right? I saw something online, essentially since like 2019, all fast food has basically doubled in price. Now, I don't want to compare ourselves to a fast food restaurant, but if you are even half paying attention, you will notice that everything is way more expensive than it used to be. It's just what is happening in our world. And, that's just the way it is. So let's revisit these probate fees. So probate, $1 million estates, $46,000 in fees, $86,000 if it's a $3 million estate, and $226,000 if it's a $10 million estate. And we're going to kind of we're going to get into what a boutique to large firm is. And our firm is a boutique firm. We are not, a large firm with 3,000 lawyers all over the world. Our firm, we charge fixed, hourly, and hybrid fees, and I'm gonna walk you through that and help explain that. But what we are seeing in California, in the marketplace, if you will, most lawyers are charging a minimum of 4,000 to about 10. Now, I'm not speaking for all lawyers, and we're not price fixing. I just talk to a lot of lawyers, and there might be some people who are charging maybe a little bit under 4, but just to give you a heads up on this, and this is why I'm doing this, there is a range, and is it 4 to 10 is kind of the range. So when you look at this and you're getting your head around it and you're trying to understand it, just be prepared for that, because attorneys who know what they're doing, that's what they're charging. And I'll get into some of the other attorneys who charge different fees. Some are higher and some are lower, but we'll certainly talk about that. So the range we're seeing in 2024, at least in the summertime, is between 4 and 10,000. But again, when you compare this to the probate fees, I mean, it's kind of a rounding error on that 226,000, probate fees. So how do lawyers charge? I gave a number. How do lawyers charge? Well, let's talk about the importance of estate planning, right? Why you want a lawyer. Estate planning's, it's a critical investment in your future and the well-being of your loved ones. I mean, I cannot emphasize this enough. If you get this wrong, it can cause disharmony in families. It can make it so that the people that you care about when you leave this earth don't get together for Thanksgiving, right? It's really important. I mean, maybe you don't care if they get together for Thanksgiving. I don't know, right? But it's really important. This is a very important part of your life, and this is your legacy. And I will tell you that when I meet with people after they've lost their parents, which is a very difficult time for the vast majority of people, many times kind of the legacy is the plan, right? That's the lasting legacy. And sometimes the last few things that happen in the last few months of life, that becomes a legacy. So very, very important. Lawyer fees can vary wildly depending on the complexity of your estate and the billing structure. So it has to do with value. Obviously, if you have a small estate that's very complex, very hairy, very thorny, you just don't have the money to pay to spend a lot. But if you have a larger estate, if you have a real estate portfolio, and we were talking about this morning, and we had an attorney meeting for a client, and I said, having a real estate portfolio is really complex, and this is a very large real estate portfolio versus a portfolio of stocks, right? If you have $100 million in real estate, that's can be way more complicated than $100 million in stock. Or if you have $1 million in real estate, you've got 5 homes in Oklahoma, that sounds pretty complicated, right? Versus $1 million of Apple stock. Pretty straightforward, right? So lawyer fees vary wildly, and we'll get into that. And understanding the different fee arrangements, okay, this is really important. The different fee arrangements can help you make an informed decision, because one of the things we like to do with these videos is it's a little bit like the Wizard of Oz and pulling the curtain back. My job here is to let you know, to give you this insight. And this is how it really works. And we're going to go through the different types of fees. So flat fee billing. Lawyers and attorneys can charge a fixed fee for a specific package of estate planning services. So typically this is going to include your consultation. It might include the signing of your documents. It's possible they could charge you for notary fees or have a third-party notary, but typically it's going to include the meeting or meetings, the living trust, will, power of attorney for property, power of attorney for healthcare, HIPAA authorization, deeds, whatever it is. And it is a fixed fee for that bundle of services. There's a beginning date and there's an end date. Now, under California ethics rules, your lawyer is going to send you what's called a closing letter, or should send you a closing letter. And that closing letter says, thank you for hiring the firm. Our services are now concluded. The reason the lawyer does that is that starts a statute of limitations period. So if the lawyer messed up, their insurance company wants to send them these closing letters. It's not that they're trying to get rid of you and they don't want to see you as a lawyer for future services. So if you get a little hurt emotionally by getting that it's like a breakup letter from your lawyer. The lawyer's not being mean, okay? This is something that lawyers are nudged to do, to say that the services that you've hired us to do are completed, so that if you go back to them to do an amendment or do some other work, expect to pay a fee, right? Because the work, that fixed fee, that flat fee, is over. So the work, it's kind of like building a deck on the back of your patio, right? There's a beginning date and an end date, and here's your stuff, and that's it. So the pros are, it provides transparency and predictable costs up front, right? So if you're the consumer, you go, wow, you're going to charge me, I don't know, 7,500, whatever it is, and I'm going to get my estate plan, and I know that's what it's going to cost me. Now, my wife happens to like this type of arrangement. She says, I don't want other type of, I just want to know how much is it going to be, and what's going on. So the cons, this may not be suitable for highly complex estates or those with unique needs that require additional customization. So I would say, if you have a larger estate or a more complicated estate, right? If you have multiple pieces of property, or you've got, you're not sure what to do, or there's conflict in your family, this may not be good. If you're an engineer, you're by definition a smart person and very detail oriented, and sometimes that drives lawyers absolutely nuts. I got to tell you, I love engineers, and they're very detail oriented. But sometimes it drives. This is what lawyers say behind, out of earshot of the client, and so a lot of times that flat fee billing doesn't have an hourly component. It's just kind of, and our firm, look, we do hourly. Sometimes we do hourly or flat fee billing for clients, right? If we, after that initial consult, we say, you know what, a flat fee is appropriate for you, and this is what the fee is going to be, and this is the scope of services. Hourly billing is where lawyers and attorneys charge a set hourly rate for the time spent working on your case. So, you work for an hour, you charge a client an hour. This offers flexibility for complex or unique estate plans that require extensive customization. Sometimes so if you have a larger estate, oftentimes it's hourly, right? Because there's no other way to fairly, and this is fair for not only the client, but also the lawyer, because sometimes we don't even know if you need this stuff, right? So if you say, gee, I want to investigate, are these 8 different types of trusts, which one's good for me? Rather than saying, oh, going through a diagnostic process for 5 or 6 hours and then charging a fee for a document, right? It makes more sense to do the hourly arrangement and the attorney to track his or her time. So again, this offers flexibility for complex estate plans. The problem is the total cost can be unpredictable. Now, many times the total cost is the same as the flat fee, okay? But it's unpredictable. And so broadly speaking, if a law firm handles a number of cases, when you average everything out, you're kind of averaged on the flat fee, but it's variable for the client because the client's only having that sort of single case with the firm. So certainly if it morphs into being a more complex estate, then it can be unpredictable. Retainer fee billing is so hourly billing is where the attorney works for an hour and sends you a bill. Retainer fee is where you say, I'm going to make an upfront payment to the lawyer to secure the lawyer's services, and hourly fees are deducted from the retainer. So this is an advance of fees retainer under California rules of professional conduct. So you make a deposit of $5,000, the lawyer bills, sends you a bill, and then you pay it, right? So and we'll cover, there's a slight variation on this. We'll cover, I think we're covering that in a couple of slides, but this does offer some predictability, ensures the attorney's availability. That's very important. If you do a pure hourly, the lawyer doesn't know if they're going to if you're going to pay them, and but if the money's in the trust account, they know if they bill, they're going to draw it out of the trust account. They're going to be working on your matter, maybe before a different matter. So additional fees can be incurred if the retainer's depleted, right, before the estate plan is complete. So if you put an estate plan, if a retainer of $5,000 and you hit the 5,000 and it's not complete, you're going to have to come up with some more money. So that's a little bit like the hourly fee billing. Then there's an evergreen retainer fee billing, and we use these a lot in our firm. You make an upfront payment to secure the lawyer's or attorney's services, and as the lawyer bills, it's deducted from that retainer. But you're always maintaining a minimum retainer. So if you pay a retainer of $5,000 and the attorney bills $1,000 and there's $4,000 left, you as the client still pay another $1,000 to fill that back up to $5,000. That reduces or pretty much eliminates collections for a lawyer, and it allows us to be more efficient with our time and reduce the overall cost to clients, because we're not spending time chasing people who haven't paid us. So again, I'm giving you a little bit, pulling the curtain back, as it were. This offers some cost predictability, ensures attorneys' availability, and again, additional payments may be incurred even before the estate is completed. And these are really the different ways. I'm not getting into contingency fees and other things because we're not those type of contingency fee lawyers. There are other costs to consider, though: recording and other filing fees, which are not cheap in California. In states like Florida, they're very expensive. So Florida has no state income tax, but they do have these higher recording fees and other types of taxes or other types of charges. Appraisal fees. So if you're making a gift of property, you have to have typically the real estate is appraised, and then typically it's gifted through an entity, and we cover this in other webinars, and that entity is valued. So that can run into the tens of thousands of dollars pretty quickly. So bear in mind, if you have a large estate, maybe you have a $50 million estate, and you're looking at giving, $13 million before the end of 2025. And again, we cover this in other webinars. Know that there are attorney's fees as well as other costs to bear in mind. So final thoughts on fees. I would recommend that you discuss your fees up front with a potential lawyer or attorney to find the arrangement that it really suits you and your budget, right? And don't hesitate. Please do not hesitate to ask for a written fee agreement outlining all the charges and payment terms. We do that in our firm. California's ethics rules say that if the fees are over $1,000, you should have a written fee agreement. When a trustee hires a law firm, the trustee must have a written fee agreement. So the investment in estate planning is an investment. Remember, it's an investment in your peace of mind and the future security of your loved ones. Probate fees are statutory. So we talked about hourly. Probate fees are not hourly. They're based on a percentage of the estate, and this is what's called a statutory fee. Now, these are the maximum fees that an attorney can charge. So if if you're meeting with a lawyer who wants to handle your probate fee, those are the maximum fees. Most lawyers who know what they're doing charge the maximum fees. Are they negotiable? Theoretically, they're negotiable. We just do not see, we used to see a little bit more negotiation. We're just simply not seeing it anymore because, frankly, lawyers are busy. Because trained estate planning lawyers and trained probate lawyers are in very short supply. The whole generation of people who practiced probate and trust law, there's a whole generation that's retiring. Baby boomers retiring in droves, right? I'm Gen X. There's not a lot of us around. And not a lot of those people mentored enough people. So what we're finding is we're having a rapidly aging population in California, including the lawyers that used to help people with estate planning and probate matters. Those people are retiring just at the time when more people are asking for the services. So there's some pretty powerful market forces in play here that are changing the way that people engage with lawyers, different than it was really before COVID. So the days of free consults, I would say, are largely over. Except for the contingency fee lawyers. So if you're injured on your motorcycle and you call the bike lawyers, they're going to talk to you for free. But the days of the free estate planning consult, I would say they're largely over. I do see online some people who advertise a free consult, but again, nothing's free. There is no free lunch. That'll be baked in typically to a flat fee. So you're effectively paying it anyway. Okay. So in our firm, we don't do free consults. Those are paid consults. And certainly if you reach out to us, they can walk you through what that looks like. So let's break down what will creating a living trust cost in 2024. Well, online, you can go online, right? There are more and more online providers. It used to be you'd go to, potentially go to a paralegal service. I would say $0 to $1,000, right? Because well, first of all, you can just go to public records. You can go to a courthouse and you can look at a trust that's attached to a trust petition, and that trust is public record. And theoretically, you could just copy it and swap out the names. I'd recommend that is a really bad idea. Okay. That's like a drunk monkey with a revolver, right? You don't, I'm not saying you're a drunk monkey and you're holding a revolver. What I'm saying is, if you don't know what you don't know, that's really dangerous. I think it's a really bad idea, but can you do it? Yeah. I mean, right. You could do it. Employer sponsored plan. Some employers have essentially prepaid legal. The problem with prepaid legal, number one, the reimbursement is comically low. So the lawyers who are, in my experience, the lawyers who are handling these are either making a very bad business decision, or maybe they just don't have the expertise, or they can't generate demand, right? They can't get clients. And sometimes, and I won't mention the plans, but the plans will say, we will, reimburse the lawyer $750 for a living trust. And the lawyer will say, well, that's for a living trust, but if you want these extra features, you have to pay more, right? So you're going to end up paying more anyway. So I'm not sure if that is works with those agreements, but I do see lawyers where they're getting a low reimbursement from these essentially employer-sponsored insurance plans, but then they're telling the person that's meeting with them, oh, if you want this better stuff, then you're going to pay the difference. Um, I, I I'm just telling you that's what's happening. The solo or micro firm, this is the one man or one woman show, or maybe two lawyers. We do see a lot of fixed, and we do see a lot of hourly, and we're seeing that range is typically like 2,500 to 7,500, and I would say it's similar to the boutique and the large firms. The risk here is the solo or micro firm is if it's a one person show and that person closes their practice and you need something, they're just not going to be around. And that's a little scary because you're talking about something that's going to survive you, your plan. So the boutique firms, the large firms, these have typically fixed hourly and hybrid arrangements. The hybrid arrangement requires, the reason I say you see this in the boutique and the large firm, the hybrid arrangement requires more sophisticated accounting methods that typically you do not see in a solo practitioner or a micro firm, maybe two lawyers. So that's why I added that in there. And what we're seeing is broadly speaking, 4,500 to about 10,000 and up. Now, some of the estate plans that we do for clients, you know, a client leaps to mind. They had a $30 million estate. Their estate plan was $13,000. You might have another client with $5 million estate and their estate plan is 6,000. So it's not like it's a percentage of your estate, but typically the more assets you have, the more types of planning you're doing. So you're doing things more for estate tax planning purposes on that foundational plan. So that's the boutique to large firm. And so why isn't estate planning 1,500 or 2,500 anymore? You know, when I started 30 years ago, that's what I was charging, and that's why I put it up there. Inflation, laws of service, wage inflation is a culprit. My dad's CPA raised his fees 40% last year. 40%. Again, lawyers are retiring in droves right at the same time that people are demanding their services. Baby boomers, they're aging out. And on January 1, 2026, the amount that you can pass free of death tax is getting cut in half from 13 million to probably about 7 million adjusted for inflation. And taxes are going from 40 to 45%. A lot of people are running to the lawyer's office. If you have assets greater than 13 million, they're coming into the lawyer's office to say, I need to do something, right? I need to get on this now, or assets greater than 7 million. A lot of people are coming and saying, I need to do something. And I would say most estate planning attorneys, when you look at the hourly, most estate planning attorneys who know what they're doing are charging 500 or more per hour. Now, again, it's like a state average in California. If you're in the Bay Area or LA, definitely this is the number you're seeing, if not higher. You get out into the east of Highway 5, and it might be a little bit lower, which is kind of Eastern California. But again, I'm broadly speaking, just giving you an idea. So you might go online and Google, how much does a lawyer charge? And I've seen the Google response, $120 an hour. I don't know where they're getting that data from, because I don't think it's real. But in the real world, that's what savvy, this is what trained estate planning attorneys, that's typically what they're charging. So what will updating a living trust cost in 2024? Let's say you have a living trust and you say, you know what, that grandkid got born and I want to just add something to it. I want to add $50,000 for my grandkid when, if I pass away and the grandkid's around. The solar or micro firm, it might be a restatement, right? It might be like you go into the lawyer's office and they say, gee, Mr. and Mrs. McGillicuddy, you did your estate plan 15 years ago, and it's great that you have a grandchild, but so much has changed. We need to do what's called a restatement. Well, I would ask you to expect to pay these fees, right? Because a restatement is where you take all of the documents, the trust, you throw out the trust, you replace it with a new trust. It's a big amendment that replaces all the terms of the prior trust. And so what this restatement does is it keeps the original name of your trust. So if you put your house and your rental property in your trust, you don't have to retitle that. So it's kind of like buying a house with an address and you want to do a bunch of remodeling, and the contractor shows up and says, you know what, it's going to be cheaper if you tear the house down and rebuild it. So if you've ever remodeled, probably know what I'm talking about. It's the same thing. So you keep your same address, but you have a new structure, right? That's what a restatement is. And so those are going to be, if you're doing a restatement that requires a big change, those are the fees that you're going to see, the solo and micro, that 2,500 to 10,000. So that's the amendment versus a restatement. An amendment is changing a particular provision of a trust. So I have a trust that was made in 2012, and I do an amendment in 2024 that changes the trustee. So this is very important. So when you change a trustee, you often need to change your pour over will because you're changing the executor many times, your agent under the durable power of attorney for property, probably the person, a durable power of attorney for under advanced healthcare directive, HIPAA authorization. So it requires altering several documents. So even if you're just changing who the trustee is, many times that's a much larger project than you might think. It's kind of pulling the thread on a sweater. Please, it is a really bad idea to cross out something or write changes on a signed document. So you're altering a document that's been acknowledged before a notary public is a really good way to end up in probate court. And we see it because the judge says, here's what judges say. I see that you drew a line through the trustee. That means that trustee can't serve. And when somebody wrote a name above that, I don't know who that was that wrote that name, right? So you get into these issues of, is this really what you wanted? And if you're dead or incapacitated, you're not around to say what you want. So the method of amending a trust is to create another document that changes those provisions. So when a person dies, a trust can become irrevocable. When a trust becomes irrevocable, the trustee must serve a notice called the Probate Code 16061.7 notice. And if you've ever gone through trust administration, this might be familiar. You have to send a copy of the trust to everyone who's named in the trust and everyone who inherits if the trust were set aside. So if you want to disinherit your jerk son, he's going to be entitled to notice. He's going to be entitled to see a copy of that trust under California law. So very, very important. When you do a restatement, you change all the terms and you reset that clock on who you need to notice. So if you have in your trust $50,000 going to your best friend, and then you don't like your best friend anymore, and you do an amendment eliminating your best friend for that $50,000 gift, when you die, your best friend is going to get that Probate Code Section 16061.7 notification. If you do a restatement, your best friend isn't entitled to anything. Now, it is discoverable in litigation, but there's no affirmative requirement on the trustee to send that best friend who used to inherit, but who no longer inherits because you did a restatement. There's no requirement to send that person a notification. Again, it is discoverable in litigation. What will small changes to a living trust cost in 2024 and why? What if all you need to do is make a small change? Well, get experienced legal counsel in deciding whether amending or restating your trust is appropriate. Again, we just covered restatements. It may be appropriate to restate your trust. You may need to update more documents than your living trust. Remember, if you change your trustee, but speak with your lawyer. And then these are often hourly engagements. So if you're one of our clients and you call us back and you say, I need to change my trustee, probably going to be an hourly engagement if it's not a restatement. But many lawyers will do that. The problem is the online people and a lot of these other types of, if you're not a boutique firm, if you're not a micro, small boutique or large firm, they won't amend trusts, right? They typically don't have, or they won't help you administer a trust when somebody dies. So speak with your lawyer. Again, these are often hourly. If you're not represented and you're looking for a lawyer, you can please reach out to us at CunninghamLegal.com or call us on 866-988-3956 and schedule a time to talk. So what if all you want to do is change your trustee? Again, I've mentioned this a couple of times. This is probably the single biggest little change, okay? It's like the Reno of estate planning changes, America's littlest big city, I guess they call it. If you want to change your successor trustee, they might be executor under the will and agent under the durable power of attorney. So all these documents have to be updated, and you may find that your lawyer recommends, in effect, a whole new estate plan because the time it takes to do all this, it might just be more cost effective to do a restatement, okay? So why won't another lawyer amend another lawyer's trust? It's like hot potato, okay? You remember the game Hot Potato? Lawyers have 100% personal liability for whatever goes wrong in your estate plan forever. 100% personal liability. The last lawyer to touch a matter takes on full responsibility, often relieving the prior lawyers from liability, right? So if I'm the last lawyer and I amend somebody's trust, they say, Jim, this isn't going to take too long. I just want to make this real simple change. And we do that. If there's a problem in your trust, then the people who inherit can sue me personally. Okay. So not a good outcome, right? For me. So unlike durable power of attorney and advanced healthcare directives, there are no preset statutory trust forms in California, unfortunately. So really I put no sane lawyer, which begs the question, are any lawyers truly sane, right? But no sane lawyer would do a small amendment and take on potentially millions of dollars in liability. That's why they're going to do a thorough review of the trust. They may recommend, frankly, they recommend a restatement. So if somebody comes in and they've done a trust with another lawyer, and we look at it now, our firm has acquired other law practices, and is not always the case because we're familiar with what the trust documents say, broadly speaking. So that's something, it's a case by case basis. But I would anticipate if you have have a trust done by another lawyer, and you need some changes, I would anticipate that the lawyer you go out, you seek out, whether it's our firm or another firm, would recommend a full restatement. So I'd just be prepared for that. So how often should an estate plan be reviewed? Every 5 years at least. And if there is a birth, death, divorce, marriage, if you move to another state, change who gets what or who does what, right? Trustee, change, if you want to change who the plan is, that should be reviewed. I would say review it every 3 years. The older you are, you might want to review it every year, right? As we age, things happen quickly. And you can download our estate plan review diagnostic, and there'll be a link in the notes. Once, if you're watching this on YouTube, it'll be in the notes on YouTube. And I would encourage you to just look at this every year. Maybe, I don't know, Thanksgiving time, pick it out, take it out. Do you still want that person as trustee? Do you still want those people to inherit the way you've written in your estate plan? Very important to consider. And I would say the top mistakes that people make. So fixed fee, hourly, or hybrid fee arrangement. Again, as a recap, after reviewing all, so we're going to give an example of this. So a fixed fee is where the lawyer, after reviewing all the information and client goals, the lawyer quotes the client a fixed fee for a complete estate plan that includes a living trust, pour-over will, durable power of attorney, advanced healthcare directive, and one deed. The fixed fee is honored no matter how much time is spent on the matter. And believe me, sometimes when we used to do fixed fees, and pretty much that was it, sometimes we would charge a client $4,000 and the time would be $12,000. I am not kidding, because, well, I don't know about this, I don't know about that. I want a 3-hour meeting to go over everything. And what that means is it's kind of an all you can eat. It's like going to the buffet, right? You're going to pay your, or it's like Red Lobster with the all you can eat shrimp, that they say that's why they went bankrupt. But I don't know. I haven't been to Red Lobster in a while, but I did love their biscuits. It's often coupled with a free initial consult. So a lot of times the free initial consult, so you might see people advertising online, free initial consult, our fee is a dollar amount for an estate plan. And the reason we do not advertise fees on our website is we have done legal research, and we believe it is a breach of California attorney ethics to post flat fee pricing on your website. That is our opinion. I'm not saying that other lawyers are breaching ethics by posting it on their website. What I'm saying is we don't, for that reason, and that's the reason we don't put it on our website. We're not trying to be sneaky. But realistically, though, when a lawyer's meeting with you, they're getting paid for your time. If it's free, you're paying for it. It's going to be rolled into some type of flat fee arrangement. So there's no free anymore. Hourly fee, this typically happens after reviewing the information and the client goals. The lawyer quotes their client a retainer, and the client pays it, and then the lawyer bills off that retainer no matter how much time is spent on the matter. And but sometimes an hourly fee arrangement is appropriate. And so we have this example of Wanda. So following the death of Wanda's husband, Hal, Wanda is in cognitive decline. Her assets include a home, investment properties, annuities, and IRAs. And Wanda has a child with special needs. And Wanda requires a caregiver to help with her activities of daily living. There is no way that you could do this on a flat fee, because you don't know as a lawyer what you're getting into. You really need to help the client. And in many ways, this is an example of an arrangement that would be an hourly arrangement. And in our firm, we would likely not have a flat fee for this. Now, there may be a flat fee component, but there's a lot going on here that is beyond the scope of a flat fee. So hybrid fixed fee, after reviewing all the information and the client goals, the lawyer quotes the client a hybrid fixed fee for a complete estate plan. So what this means is, let's say it's $5,000 for the estate plan or $7,500 for the estate plan. And if the hourly goes beyond $7,500, it converts to an hourly fee. That's what a hybrid fixed fee is. The client is the known unknown. So if you're like, well, I might be the client, if you're watching this, an experienced lawyer knows how much time it's going to take to get their lawyer's job done, right? When it comes to foundational estate planning, when it comes to living trust and powers of attorney and wills. But if the client doesn't provide the necessary information, if you want to save yourself money, please provide the information that the attorney's asking for, right? If you don't provide that information in a timely manner, or require multiple meetings and multiple drafts of documents and back and forth and redlining, and we'll explain this, trustee power provision, and drags out the engagement for months and keeps rescheduling meetings, that happens, okay? So the person calls and they say, well, I know I'm supposed to sign my documents at 10 a.m. today, but it's 10 minutes to 10 and I can't make it. We're going to have to reschedule for next week. Well, guess what? We've already printed out about 200 pages of documents with a date on it. So we have to trash those, right? Or recycle them. And we got to print out a whole bunch of new documents. That takes time. That takes resources. That takes effort. And so the variable for a law firm is really how the client conducts the client, right, themselves. So the hybrid fixed fee agreement is one solution. And frankly, some people don't care. Some people say, well, I'm not ready to sign the documents, or I know I had that appointment, but something else came up. And if you have to charge me, that's okay. And that's fine. But the hybrid fixed fee typically solves for that problem. So a key terms in a hybrid fixed fee agreement. A hybrid fixed fee basis means you will be charged a minimum fixed fee in the amount payable as indicated. The firm will calculate and apply hourly fees toward the fixed minimum fee with billing statements generated internally for our purposes. And if the fees exceed the minimum fixed fee indicated, the firm reserves the right to bill you on an hourly basis. And after the matter is converted from a fixed fee basis to an hourly basis, a complete billing statement will be provided for your review. That is in our fee agreement. This is right out of our fee agreement. And this can be helpful in bridging the gap between the needs of the client and the needs of the lawyer. So if there's an unknown in there, we're seeing this a lot. And our firm is not the only firm doing this, by the way. I would say the firms that really kind of pay attention to this, and if you're not paying attention to how you're running your business as a lawyer, you're going to be out of business, right? It's just the way the world is now. So we really pay attention to this. We want to be around. We want to pay our people appropriately. We want them to stick around, right? And so we really do pay attention to this. How to best prepare before the meeting with the lawyer. Educate yourself. If you go to our YouTube, you might be watching this on YouTube, but we're doing this live. We have over 200 videos in this format of education, right? It's free. This is just out there for the world. Subscribe to our YouTube channel. And you click the bell, you'll get alerted by Savvy Estate Planning, what you need to know before you hire a right lawyer, right? That's a really good way because we cover a lot of concepts. We cover a lot of just things that are good to know before you go to the lawyer. This is very important, before you go to the lawyer. And be prepared to discuss key decisions. Who will oversee you, right? If you become incapacitated, who's going to take care of you? Who's going to take care of your stuff? Who gets it, right? Think about this before you go to the lawyer, right? Because the lawyer's going to ask you. I don't care what lawyer you go to do estate planning. They're going to ask the same question. They're going to ask these questions, right? And please give information when asked. The information provided to a lawyer is maintained in confidence. Very important to understand. If you use a non-lawyer, that is not privilege. So communications with a lawyer are protected by attorney-client privilege. If you do not use a lawyer, you are not protected by attorney-client privilege. And on that happy note, we will end with our office locations in Northern and Southern California, the Golden Gate Bridge and palm trees. Subscribe to our YouTube page. If you love our webinars, please go to Google and give us a favorable review. We love favorable reviews. I will be on a hiatus for 3 weeks, and Tasha is going to do my law partner, Tasha, is going to do second marriages and living trust, blended families and their unique challenges. So this is a good one. So think of Brady Bunch. That's what Tasha's going to be talking about. So we'll open it up for questions. If you're watching this on YouTube, please continue watching because magically another video, if you've made it this far, another video will roll up right after this one. Thanks for watching.